All right.
You are Juan Jose Serna.
Yes, sir.
Mr. Serna, you now stand charged yet again with burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Right off the bat, notice the judge spelling out the defendant's rights. This isn't just routine. Every word here protects against appeals later. Do you think suspects actually stay silent when warned, or do they usually talk themselves into deeper trouble?
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to a motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking.
This is a classic burglary that'll set off the alarm circle back. When it's quiet, almost
walking up, jumped out of her motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and everybody was then heard the male tell the driver, go, go.
But in court,
another
these little details can make or break probable cause. What would you have done if you were the car's owner walking up at that moment?
That the suspect jumped out of a motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and everybody was then heard the male tell the driver, go, go, go. Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect's motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat, and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. Yeah. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr. Serna is the second. Looks like the second individual that was in the passenger, that was in the driver's seat whenever the complaining witness came out of the vehicle, is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable
They have both of them in there.
Whoa, look at this rap sheet theft. Burglary assault. It's like a criminal buffet. Judges don't just see the new charge. They see the whole pattern question for you should pass crime. Weight is heavily on current cases, or should each charge stand alone?
In the car, being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
We're in the car attempting to.
I have the
Because I thought it read that one person wearing a camouflage hoodie was in the car.
That was the second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Serna, let's go through your stuff. Theft of wire or cable. Theft. Trespass. Evading arrest. Burglary of a motor vehicle. Theft. Assault of a family member. Attempted burglary of a motor vehicle. Burglary of a motor vehicle. Theft. Third. Burglary of a motor vehicle. Unauthorized use of a motor vehicle. evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you
And here is the judge dropping real talk, basically warning the defendant that messing with cars in Houston to get you shot. This mix of legal authority and blunt honesty is rare. Do you think judges should speak this way, or does it cross into personal opinion?
Buck with the wrong person, they're going to shoot your ass dead. It happens time after time.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at $10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at $10,000. I'm asking the court to keep it in place.
So there's nothing for me to revoke because he has not made bond on
In felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. I don't know if you're going to get out, but if you do.
This judge isn't sugarcoating it, straight up calling out community risks. Do you agree courts should be this brutally honest, or is it crossing the line? Comment what you'd do if you were on the bench.
I'm ordering you to have home confinement. I don't want you